Namaskar. I Adv.Juilee welcome you all in my YouTube channel. In last video, I have discussed about whether you should make will or not and what factors to be considered if you want to make a will. Now, if you have not watched that video yet, then please go and watch that video first. After considering all those factors, if you have came to the conclusion that you need to make a will, then today's video is for you. In this video, I'm going to explain about everything regarding the will, including the legal provisions and some practical aspects. So let's get started. So firstly, let's understand what is the will. All provisions regarding the will are covered in the Indian Succession Act 1925. The definition of the will is given in section 2 of this act. Various definitions are given, and in that, will is defined in 3 aspects. First, will is an legal declaration of intention of a testator. Here the testator means the person who is making the will is called as testator in the act. So will is legal declaration of intention of this testator. The second part is this intention is regarding his property. So you can make will regarding your own property, that's obvious, and not regarding someone else's property. And the third and most important aspect is that this declaration or intention of the testator will take effect only after his death. So will is very peculiar and special document in which the effect will be given only after death of the testator. Therefore, it is very important document, because person making the will is not going to explain anything when that will has to give an effect to. So if you make a will, you are not going to be there to give any addition, clarification, or to delete something. Therefore, it is most important to make this document very, very carefully. So this is about the definition of the will. Now, what makes the valid will? There are 2 aspects to it. The first is about capacity of the testator. That means the person making the will should be capable to make the will. And the second part is about how to execute that will. So the person must be capable, but then how the valid will should be executed, that is given in the second part, and we will cover both these parts. So the first part is about the capacity of the testator. Now the Indian Succession Act 1925 states that every person who is of the sound mind and who is not minor can make a will. So there are 2 important aspects about the capability. That person should be of the sound mind. He should understand what he is making, what is the effect of it. And the second part is, of course, he shouldn't be the minor. Okay, so these are the 2 important capabilities. And there are certain explanations given under this capability of the testator. So the first is that married woman can make a will. Now this act is made in 1925. So considering that, they have given clear explanation that married woman is capable of making the will. The second part is that even a blind, deaf and dumb person can make a will if they are in position to understand what they are making and what will be effect of it. They are capable of making the will. Thirdly, suppose a person is of unsound mind. Okay, so majorly he is of unsound mind, but there are certain intervals in which he is of the sound mind, and in that sound interval, if he makes the will, then that will is a valid will. And the fourth point is that suppose the person is perfectly mentally sound, but at particular time he is intoxicated, or he's ill, or he's under influence of drugs. So that's why in those period he's not of a sound mind. Then any will made by such normal person during such intervals is not a valid will. So these are the 4 important explanations which are given under the act, and this makes clear about what is the capacity of the testator. So all these capable persons can make a will. Now this is the first aspect about what makes the capacity of testator. Now the second part is about valid execution of the will. So suppose you are a capable person under the law to make a will, Now, how that will is to be executed. So let's understand the simplest scenario. The testator signs the will. So suppose there is a person who wants to make his will. So he signs the will in presence of at least two attesting witnesses. So suppose there is A's will, B and C are his witnesses. So A signs his will in the presence of B and C. B and C also sign the will as attesting witness in presence of A and in presence of each other. So all three people are present together and they are signing in each other's presence. This is the most ideal scenario of execution of the will, and this is perfectly valid will. Now this is the ideal scenario, but the life is not that ideal, right? So suppose the testator is not able to sign the will due to any reason. So I had this one client who was paralytic, so she was not able to sign. Though she used to sign, she was not able to sign when she wanted to make a will. So in such situation, the testator can put thumb impression on his mark. That is also covered under the law, and that is perfectly valid. Okay, but then explanation has to be given in the will that the testator is not able to sign because of this medical condition, so she's putting her thumb impression, and the proper doctor certificate is advisable to be attached to it. So in such cases, mark of the testator is also fine to be given. And again, the two witnesses has to be there. They see the testator putting the thumb impression and everything, and that is also perfectly fine, and they are signing in presence of each other. Now the third scenario is even more complicated. Suppose that the testator is not able to sign nor put the thumb impression. Now there are also certain situations in which people are so paralytic that they won't be able to even say put thumb impression or raise their hands. So in such scenarios, if the testator instructs any other person to sign as per his instructions and in his presence, so suppose A is not able to sign or put any thumb impression, but he tells said person D to sign the will on his behalf and in his presence, and the other two witnesses B and C are also present. So this scenario is also a valid execution of the will, which is a rare scenario, but law covers all these aspects. Okay, so this is one aspect regarding the execution of will. Now let comes to the second part, which is about the attesting witnesses. Now as I told you, minimum two attesting witnesses are required. Now you can have more than two witnesses, and the ideal scenario is witnesses and testator are present at the same time. But what if suppose due to any reason two witnesses are not able to be present at the same time? Then what is the scenario? The law covers that also. So suppose testator A signs the will in presence of B, and B also signs in presence of A. Okay, so one witness and a testator is there. Now the A, after these signatures, go to C person who is another witness and says to him that, see, this is my sign. I sign in presence of B who is first witness. Now you please sign as a second attesting witness. So C also signs in A's presence, right? But B was not there because B has already signed. This scenario is also covered in the act, and this is also validly executed will. But what is important is that both the witnesses should sign in the presence of the testator, which is A, and suppose C, which is the second witness, should receive personal acknowledgement from the A that, you know, I have signed this will and B has also signed this will. Now you please sign the will as a second attesting witness. So this is also covered under the act. So law covers all these aspects and the complexities. So hope this makes clear about the valid execution of the will. Now regarding the witnesses, witnesses need not know the contents of the will. Okay, so it is not necessary that witnesses should know what is written in the will. The role of the witnesses is that they must know the testator personally, and they should be able to testify or give evidence that they know the testator and the testator signed in their presence, or as I explained that testator personally told them that he has signed the will. Okay, so that is the role of the witnesses. And the another important aspect here is that the beneficiary of the will should not be the witnesses. So if in your will you are giving any benefit to B, then B cannot act as your witness. Or suppose if you are giving any benefit to B's wife or B's husband, like the spouse of the B, in that scenario also the B cannot act as attesting witness. So this is important. Now there are certain interpretation in which people say that no, this is allowed and everything, but that's complex. The ideal scenario would be, please try to avoid any beneficiary to be your witnesses. That is strictly not advisable. Even the spouse of the person of the witness should not be the beneficiary. So that is also important to keep in mind. Okay, so this is about the witnesses of the will. Now suppose you want to make any alteration or deletion or addition in the will. For example, you want to write a date of your will, or you want to cut anything, or want to add something in your already handwritten or typed will, then of course you can do that in front of the witnesses only. That is advisable. And then wherever you make such correction, addition, deletion, the testator should always put his initial or signature in the margin near that word or addition, deletion, and the witnesses should also put their signatures in the margin. That is the ideal scenario, so that all these corrections can also be proved in the court when you have to take a probate, if it is mandatory. So the witnesses can say that okay, all these corrections, deletions are made in our presence and there were signatures of everybody. So this is also an important aspect which we need to keep in mind. The another important aspect is that the marriage of the testator revokes the will under the law. So suppose you have made the will before your marriage and then you get married, then that will which you made before the marriage automatically gets cancelled. You don't need to cancel it specifically, but it automatically gets cancelled. So after the marriage you have to make a fresh will. That is very important. Now, in first part of this video, I have covered all the legal provisions of the Indian Succession Act. So whatever I have explained you regarding all the legal provision, this is covered in various sections of the Indian Succession Act 1925. Now let's cover some practical aspects about making your will. These are all from my experiences, that what makes a good and valid will. Okay, so let's understand that. The first point, personal details. Mention your complete name, age, address, religion, Aadhaar card, PAN card number. So when you are making the will, it is very important that you mention your full name in the will. In the first para itself, I, Mr. So and so, Mrs. So and so, whatever. And if you have any alias name, like if you have some two similar names, or if there are any spellings difference in your names, then all that must be explained in the first para itself. Then please mention your age, your address. The religion is to be mentioned because based on your religion, which personal succession law is applicable to you, that is decided, which we discussed in the earlier video, where I explained about the whether to make will or not. So religion is to be mentioned, and to be extra sure, please mention your Aadhaar card and PAN card number as well. The second point, specifically revoke earlier will if any, and mention that this is your last will. So this is also very important. You can make n number of wills in your lifetime. Okay, you can make one will today. Maybe after 2 years, there are some certain change in circumstances. You want to make changes in the will. So you can cancel the earlier will, or you can make a codicil. I would make a separate video about the codicils. But suppose you have any earlier will and now you are making a second will, then please mention that I have the earlier will dated so and so, and by this new will I am specifically revoking the earlier will. This is very important. The third point, mention names of all legal heirs beneficiary relatives and their relationship with you. So after explaining about yourself revoking the earlier will, please mention names of all your legal heirs as per respective succession law, who are your immediate legal heirs, your family members, their complete name and their relationship with you. Suppose some people who are not your immediate legal relatives, but then you want to give some benefits, bequest to them, like suppose your niece or nephew or some uncle, aunt, then please mention their names and relationship with you as well. Fourth point, advisable to appoint at least 2 executors in the will so that probate can be obtained where it is mandatory. Beneficiaries can be executors. So this is the next important point. It is practically advisable that you appoint at least 2 executors in your will, so that if one executor is not ready or unfortunately dies, or he wants to renounce anything, then another executor at least will be there to take probate of the will where it is mandatory. Now probate is not mandatory in all the jurisdiction, in all the cases. I will cover that in a separate video. But suppose it is mandatory in your region to take probate of your will, then if executor is there, then only probate can be obtained. So mention at least 2 executors which can act jointly or alternatively. You can mention more than 2 executors as well. And beneficiary of the will can be executor. See, beneficiary can't be witness, but he or she can be executor. So suppose in your will you are giving all your property to your daughter, you can appoint your daughter as executrix. The lady is called as executrix, and that is perfectly fine. Fifth point, direct your executors to pay all your debt first and other necessary expenses, and then administer your property. So I'm going sequentially, that you have appointed your executors in your will now. Now then you have to specifically direct your executors that first pay my debts, and give details about if you have any outstanding borrowings, loan, etc. So you should direct your executors to first pay the debts out of your property, then pay other necessary expenses like expenses of funeral expenses or probate fees or professional fees. Necessary expenses are to be paid, and then after deducting all these expenses, the remaining property is to be distributed as mentioned in the will. Mention that will is made in sound mind and out of free will without any coercion, undue influence. So this is very, very important that you have to specifically mention that you are making this will out of your own free will, your own accord, desire, and without any undue influence or coercion. That is important to when you have to get your will probated, not you but your legal heirs, executors, then this line is very important, because will has to be made with the free will of the testator. So this needs to be specifically mentioned. Mention that the properties are your self-acquired properties. You can include undivided share from your ancestral properties. Now, as I have explained that the will is legal declaration regarding his own properties, of the testator properties. So you have to specifically mention that the properties which you are bequeathing by this will are your own self-acquired properties. Also, as per the section 30 of the Hindu Succession Act, you can also make a will of your undivided share in your ancestral property. So suppose you have your father's property in which there are other 3 siblings with you. So you have 25% undivided share in that ancestral property, which you can include in your will. The 8th point, you can do specific bequest or general bequests. So in the will, I have seen that many clients make a very general bequest in which they say all the properties which I have everywhere, whether movable, immovable, wherever situated, will go to say my son, daughter, or my spouse. So this is a general bequest where you don't want to give all the details in your will, which is fine, which is one way. Or the second way is a specific bequest in which you mention your assets also specifically, that so and so flat, so and so FD, or FDs in so and so bank, or locker, contents of the locker, or your demat account details. So all these you mention specifically, and then you make specific bequest that okay, this property should go to my both the sons, this should go to my wife, husband, whatever. So that is specific bequest. If you are making the general bequest where you are saying, okay, everything should go to so and so person, make sure that you have made a separate file regarding all your assets and all your legal heirs know that what your assets are. Because if probate is mandatory, then with the probate we have to give schedule of the assets. So it is very important that your legal heirs know what all your assets are. 9th point, the language of the will should be simple, clear, complete and consistent. So while making your will, make sure that your language is very clear. There should not be any ambiguity. It should be consistent. In first line, in first point, you should not say this flat will go to my son. In next line, you should not say, okay, this flat will go to my daughter. Don't use such confusing language. Use simple, clear, consistent language in your will. So after you make your will, please read it thoroughly to understand there are no any inconsistencies or nothing is incomplete. Okay, there shouldn't be any need to add words in your will to make it a meaning. So please read and understand that your will is complete in itself. 10th point, always mention name of the alternate beneficiary in case of death of the primary beneficiary before your death. So this is also very important. Suppose you have made the will and you have given particular property to say your son, and unfortunately, God forbids, if so happened that he dies before you, or in such cases, it is also advisable that you make an alternate beneficiary where you mention, suppose my son predeceases me, he's not there at the time of my death, then the property given to son will go to his legal heirs or will go to his son, daughters, his wife, whatever. So this making alternate beneficiary arrangement is very important, so that in case of such events you don't have to change your will specifically. 11th point, give a detailed justification if you are excluding any legal heir. Now this is also very important, because suppose you don't give any justification for excluding any legal heir, then though that will can be challenged as unnatural will. So suppose you have two sons and because of any reason you want to exclude one of them, you had any issue, then please mention that specifically that you are excluding this legal heir because of this and this reason, and because of this reason the will should not be challenged of being unnatural. So if you give this explanation, that gives your will more weightage. Second last point is include residuary clause. So in your will, after you have given the specific points like, okay, this should go to this, whatever, then one point you should cover at the end, which is called as a residuary clause, in which you will say that if any property is by mistake is not included here, or because of the any reason some new property is acquired by me, so then all such properties should be given to so and so person. So this is called as a residuary clause, and it is very important to include this clause, because suppose you are making will now, but that will take effect only after your death, so which may be the period of 10-12 years or more. So this residuary clause makes sure that all such properties which were not mentioned in your will are covered. The last 13th point, witness should be younger than the testator. They must be trusted people. So the role of witnesses is very important in proving your will. In case of the probate, at least one attesting witness need to file his affidavit before the court of law. So you have to make sure that the witnesses are younger than you. So naturally they will outlive you in general circumstances. And the witnesses must be trusted people who will help your legal heirs to get the probate. So they will not say that, okay, we don't want to sign the affidavit, we don't want to, do all these things in the court. It should not happen. So the witnesses should be trusted people. Please don't make your staff or a driver as witness. I've seen my clients in which one of the witnesses is their driver, and when they have to get the will probated, then they say, oh, that driver is not in our service anymore, or that staff is not in our service anymore, not in our office. So this should not happen. So please make sure that your witnesses are your trusted people, your relative or your close friends who will help your legal heirs in proving that will after your death whenever that is required. Okay, so these are the important practical aspects about making your will. I hope you will find this video very useful, where you will understand the legal provisions as well as the practical aspects of the will. And if you are considering to making your own will, then please watch this video again and again to understand the points and make your will very clearly, thoroughly, completely. I hope you will find this video useful. Thank you for watching. If you like the video, please share it, subscribe to the channel. I'll see you in the next video. Thank you.